Please be seated. We'll hear argument in case number 240245 in re Zaidi.
May it please the court, Mr. Harrison will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. In this case, and in similar cases, the court has previously said, in disqualification cases, the court's analysis begins with the premise that disqualification is a severe measure. It can result in immediate harm because it deprives a party of its chosen counsel and can disrupt court proceedings. The court has also said that particularly in non-lawyer situations, as we have here, there are many reasons to not grant a motion liberally, especially when the non-lawyer is the reason behind the motion.
So in this case, the paralegal actually had worked on this exact case, right?
Yes, Your Honor. There's no issue here about substantial relationship between the cases.
So wouldn't that just be blatantly unfair for that person to be involved in the case when they've learned things from the other side?
Well, Your Honor, a couple points. First, there is an issue as to whether or not this person was a legal secretary or a paralegal. But to answer your question directly, that's the reason that we have the factors that are considered in the Phoenix Founders case and the cases that have followed. You don't look at you don't just conclude, as you do with attorneys, but with non-lawyer parties, you don't just conclude that it's blatantly unfair and it's improper. You then consider the factors of Phoenix Founders and the considerations that go into those factors in determining whether or not there was a reasonable likelihood of disclosure, or alternatively, whether or not the risk of disclosure was at a minimum acceptable level.
Well, we've said in cases that part of that is opened up if the non-lawyer was instructed not to work on cases that she already had worked on, and that just didn't happen here, right?
That's correct, Your Honor, and specifically this court in Turner has held that if the non-lawyer is not instructed not to work on the case at the time of hiring, then you don't go into the Phoenix Founders factors. But we think this case is different, and the reason why is that the Phoenix Founders cases, the Turner case in particular, seems to focus on, and in fact did focus on, the facts there. It said on the facts before us, or language to that effect. But it focused on the fact that there was an existing conflict at the time that the non-lawyer was hired. And that's very important under the facts of this case. The court has previously said many times that it has to consider all the facts and circumstances of the case in considering any disqualification motion. Here, the non-lawyer was hired at the Hicks Thomas firm, my firm now, in 2011. There was no conflict possible at the time.
And yet there was no instruction to say if one exists or arises, you must not do it. I mean, that's what the Turner, I think, was trying to get at. It's like that kind of a wall should be erected from the very beginning. And firms, the second thing I think Turner said was, firms should be showing what they're doing to continually ensure that the non-lawyers are not working in these things. And I don't think we have anything of that either, right?
Well, I don't think that the Turner case goes quite that far, but it certainly does say that the lawyers should be instructed. But we believe in this case, where there was no existing conflict, there wasn't a conflict for 5 years, in the unusual circumstance where I brought the case over to the firm in 2016. Ms. O'Loughlin, the non-lawyer, was hired in 2011. So the issue is whether or not that rule in Turner that says there should be an instruction to the non-lawyer should bar our consideration of the Phoenix Founders factors in those circumstances. We believe it shouldn't.
When was Jackie Marlowe hired by Hicks Thomas?
I'm sorry?
When was Jackie Marlowe You said 2011 for Ms. O'Loughlin, and then you came in 2016. When did Marlowe come on and begin working against a former client?
Well, Ms. Marlowe didn't work against her former client in the context that we have before the court today. But Ms. Marlowe was retained or hired, I believe, in about 2022.
Did Marlowe receive an admonition not to do any side switching?
I don't recall. I don't know. It's not in the evidence, or it's not in the record, Your Honor. And it's not in the record whether or not Ms. O'Loughlin did, but there's an absence of that information in the record, in part because this happened in 2011. But again, I was going to point out that the court seemed to contemplate this existing conflict as not determinative, but certainly in the court's mind. When it set the rule, or restated the rule actually, in Turner, it said, the failure to provide this general instruction to a new employee, again, focusing on the time of hiring, creates an unacceptable risk of disclosure even if the hiring firm is unaware of the new employee's specific conflict. Again, seeming to consider or contemplate that there's an existing conflict at the time.
So if the
the
conflict
non-lawyer is
arises
hired.
a month later, then, no problem? I'm not sure I understand why that would really matter in terms of the risk that we're talking about, whether it exists or about to exist or will later come. It's I think what it's doing is to say, look, we're trying to avoid an absolute kill shot by having some parameters that are there. And I don't see why it makes a difference whether the conflict existed or arose later. That's what I want you to try to help me
Well,
with.
I think it depends, Your Honor, on when the conflict arose. And here the conflict arose 5 years after the fact.
What if it was 5 months?
If it were 5 months, I think then the court could consider that circumstance, the proximity of the non-lawyer's retention by the firm, whether a warning was given.
So all of this is, what really concerns me is I think we ought to have as clear rules as we possibly can. We might not always be able to have bright line rules, but when we're just saying, well, courts should take this into account, and take this into account, and take that into account, we're not really telling anybody anything. And we're going to end up with every case having to come up in the appellate system just to find out whether or not a firm is disqualified. Can you give me something that is of at least, if not a bright line, something closer than, well, there's just things to take into account, and maybe if it's this long, it's a problem, but you can consider that. Help me out with something that we can say, here's a rule that people will know in advance and not after litigation concludes.
I think the near bright line rule, Your Honor, and it would work in this case, is that if there's an existing conflict at the time, whether or not the lawyer knows of it or not, the hiring lawyer knows of it or not, then the instruction should be given. And if the instruction wasn't given in that situation, the rule in Turner would apply, that you don't consider further the Phoenix Founders factors. But in a situation where the conflict did not exist at the time, it couldn't be in the contemplation, or at least would be less likely to be in the contemplation of the hiring lawyer and the hired non-lawyer, then the court should consider the proximity in time as to which the conflict arose. Here, the conflict arose 5 years after the non-lawyer's hiring by Hicks Thomas.
And the proximity, as that becomes more attenuated, is your point that the intent was less likely to have been bad, or the prejudice is less likely to be great? Like, what exactly is it that proximity is testing for?
I think it's really testing for the prejudice that can arise and the likelihood. Prejudice is a separate inquiry, though it seems to be part of the initial inquiry under Phoenix Founders. But it does go to whether or not there is a likelihood of a disclosure of confidential information. And that's one of the key considerations in all of these cases, is that the court has to evaluate whether or not there was a substantial risk or a risk of disclosure of confidential information, or whether or not that risk was at an acceptably low level.
Are you getting at that same inquiry about the level of risk when you sort of seem to be saying in the briefing, well, she wasn't quite a paralegal, she was really only doing secretarial work? I mean, it strikes me as a distinction that would be very difficult to make and to articulate as a rule. It seems like we have a distinction between lawyers and non-lawyers, but going beyond that to try and slice and dice what makes you a paralegal versus a legal secretariat is not workable. And so I want to hear your take on why I'm wrong.
No, I'm not. You're not wrong, Your Honor. You're correct. In fact, there is at least one case where the court says we don't consider whether or not the person was whether the non-lawyer was a secretary or a paralegal or otherwise. But the significance is to the inquiry as to what was the nature of the work that was done, what was the frequency of the non-lawyer's involvement with the case. And again, here, that should be part of the inquiry, but it wasn't made. Part of the inquiry here is that not only was Ms. O'Loughlin a legal secretary within the firm, she was not assigned to work with me, and she was not assigned to work with this case. She did, and this is in the record. I'm not testifying here. She did very sporadic work, approximately 2 times a year, and this is in my affidavit, when my assistant wasn't available to do work. So in 2 instances, she did an e-filing. And in the other instances, and we specify these, we have put into the record exactly what the work was that she did do. The other instances, she assisted in typing revisions to certain pleadings. So the question then becomes, is that going to create an unacceptable risk of disclosure of confidences? And we believe that the court should have considered those facts.
I mean, I wholly believe, just personally, that there was no disclosure of improper confidences. If you wanted to get stuff from her and hide that, the last thing you would have done would be to have her e-file it so that that name was available. I totally get all of that. But the point is that we're trying to devise a rule that so clearly protects the underlying value. It's sort of a, Bentham's approach to punishing crime. The harder it is to detect, the more severe the punishment needs to be in order to adequately deter people, right? And so because what happens in a law firm of all places is so sacrosanct as a general matter, the impossibility of knowing for sure what happens, that when there are these triggering events, that's what the law is. Sometimes deep unfairness to your client. I readily would agree that this is just a very unfortunate confluence of mistakes, perhaps, if the court ends up going that direction. But that is why I'm not so sure that the facts of a particular case are sufficient to say, well, the prejudice is low here. I'm with you on that. If that really is the test, I think that you should win. But I'm not sure it's the test. Tell me why it isn't right for the court system to be thinking about the system as a whole as opposed to the particular facts of a case.
Well, I think certainly, Your Honor, the court has to do both. But with respect to the system as a whole, in these sorts of cases, the court has said the court must evaluate the facts and circumstances of each case. And that's significant here because of the severe remedy that would otherwise be imposed. So if you have bright line rules, and certainly you can in certain instances, Turner creates one. We say it doesn't apply in this case. But if you have bright line rules, in this circumstance, I think the rule is going to unfairly capture certain situations where the facts and circumstances say that it shouldn't, and that's what we have here.
If we disagree with you on that, I'm wondering if there isn't still the possibility of the case going your way on the idea that maybe the party that is affected by this has some duty to speak up quickly. Can you tell me how that would go if we say, nope, it's a bright line rule, we're not making an exception to Turner, the instruction needs to be there whether the conflict's existing or not, what then?
Well, I think there are 2 steps that then have to be taken because the court has also said in any case where there's been a violation of a disciplinary rule, and here the disciplinary rule would be 1.09 that prevents attorneys and therefore is imposed on non-lawyer staff as well from working in a conflict of interest situation. But first, the court has said we have to separately evaluate prejudice in any case of disqualification. Now, that evaluation is going to be somewhat different than simply the evaluation as to whether or not there was potential for disclosure of confidential information. Then, to your point, Your Honor, we go to whether or not there's been waiver, whether or not it appears in the case, waiver or not, whether it appears in the case that the motion is being used as a tactical device to put one party at a strategic disadvantage. And I believe we've shown that that existed here. This case has been pending now since 2009. It had half a dozen trial settings. It was tried once. It was set for trial 32 days following the filing of the motion to dismiss here. I'm sorry, not the motion to dismiss, the motion to disqualify. So there is a separate prejudice consideration, and there's also evaluation of whether or not, in this instance, the motion was used as a device to put us at a strategic disadvantage. For
Any
those
further
reasons-
questions?
Pardon me, Your Honor?
I was asking if there are any further questions.
Thank you.
Thank you, counsel. We'll hear from the real party in interest.
Andrew Mead, Chief Justice, and may it please the court. Phoenix Founders and its progeny set up a very easy test to pass with harsh consequences. The way I think of it is it's like looking both ways before you cross the road. It's really easy to do, and there could be really bad consequences if you don't do it. And what Hicks-Thomas wants here is a change to the bright line standard. I think if I'm looking at this from the court's perspective, I'm trying to figure out what's the narrowest way I could decide this case, unless the court wants to adopt some new bright line rules under Phoenix Founders or modify the existing rules, which I would doubt the court's inclined after 30 years to modify them. So where could we come up with the easiest resolution? There were 3 factual findings by the trial court, which this court isn't in position to disturb because they were found by the trial court. The first one is as to step 2 of the Phoenix Founders analysis. Step 1 is, did they work on the same or a similar matter? Done, right? So step 2 is the burden on Hicks-Thomas to show that they could not have reasonably discovered this conflict. All right? So what's their position on that? They made one argument to the trial court. They've got one argument here. We don't include our paralegals in our conflicts checks. Hold on a second. That's a terrible standard to adopt. I think the court's got 3 choices there. Never, we're not going to require paralegals to be included in conflicts checks. We're going to end up with consequences like this. We're going to say the trial court will decide whether it's reasonable to include paralegals in conflicts checks. We're going to end up with terrible results here, plus different opinions by different trial courts all over the state. Or
part of what they said on that was she was hired several years before this case came to the firm.
sure, but in their record before the trial court, what happened was they ran a conflicts check when Mr. Harrison was hired. The problem is the paralegals and their conflicts aren't included. So it only picked up conflicts for the lawyers. And that's 2 problems, I think. One, so when Miss O'Loughlin was hired, she wasn't admonished, don't work on cases that you previously worked on. When Mr. Harrison was hired, Miss O'Loughlin was not instructed, hey, if he's bringing over any cases that you may have worked on, don't work on those. And she wasn't included in the conflicts check.
Well, we don't know that she wasn't. We just don't have any evidence that she was,
Well,
right?
actually, we know she wasn't, but we also don't have any evidence that she was.
How do we know she wasn't?
Because they said so to the trial court. They said, of course she wasn't admonished. That's what they said in their briefing to the trial court. So when we filed our motion to disqualify, they wrote back, and the words were, I'm going to paraphrase part of it, but I'm going to get the first part right. Of course, we didn't include her in the conflicts check. She's just a paralegal. Okay? And they say, that should be the standard in Texas. It's not the standard at my firm. I know that, where my paralegals and my legal secretaries are included in conflicts checks. And there's no evidence that that's a reasonable standard in Texas. They had that burden. So we get to step 2. You don't even look at step 3 and step 4, admonishment and screening, if you didn't pass step 2. So Hicks-Thomas wants to take the position with this court that they could not have known of Ms. O'Loughlin's conflict. And how come they couldn't have known? Because we don't include our paralegals in our conflicts checks. Well, that's not reasonable. And so I think the court could find, and the trial court did, there are no findings of fact and conclusions of law. Hicks-Thomas didn't ask for them from the trial court. So sitting here, we've got to take everything the trial court found and imply that they made all the factual findings necessary for their judgment. So one of the things that the trial court must have done is conclude that Hicks-Thomas reasonably could have known of Ms. O'Loughlin's conflicts by, for example, sending around a list of cases that he was bringing into the firm and asking the paralegals, and the attorneys, of course, if any of them had worked on them, by including their paralegal conflicts in their database, which they put in affidavits about how their database works, but said we didn't include our paralegals, and by admonishing the paralegals, hey, by the way, if any of the cases that are coming over from this new lawyer, or the new lawyer circumstance is one, but new cases come into law firms every day. Well, maybe not every day, but you hope they do, right? So new cases come into the firm every day. Conflicts come after you're hired all the time. And so to set up a rule that excuses law firms from detecting conflicts because the case came in after they were hired, whether it's because a new lawyer brings over a docket of cases or whether a new client comes in the door or a new case from a client comes in the door, is not an acceptable standard to set. So I think of that very first part. The trial court found that Hicks-Thomas could reasonably have discovered this conflict, or put inversely, Hicks-Thomas failed to meet its burden to show that it could not reasonably have detected the conflict. So the next step you'd go to is, did they admonish, if they met that standard, we couldn't have reasonably detected this. Then you ask the question, well, did they admonish the paralegal? They didn't do it when she was hired. They didn't do it when Mr. Harrison joined the firm of Hicks-Thomas. And they didn't put that evidence before the court that they did, to your point, but also said to the court, of course we didn't because it happened after the fact. And I think what Hicks-Thomas wants the court to do is to focus on the specific conflict, but that's not the point. This case is Turner, all right? Hicks-Thomas did everything right at the wrong time. That's what Turner was. After the conflict was detected, they admonished their paralegal, don't disclose any information. After the conflict was detected, after the paralegal had already worked on it, screened the paralegal and set up all of those processes. That's exactly what Hicks-Thomas did here, after the conflict was raised. The problem is that the paralegal had been allowed to work on the case for a significant time up until then.
And so shouldn't that have been raised earlier?
When should we have raised the conflict? Is that the question? Great question. All right. So that would be the fact question number 2 for the trial court to determine, not for the appellate court to determine. When should the conflict have been raised? And they're part of the record, of course. There are 2 things they say should have alerted us to the conflict. One is the electronic filing certificate that comes along with the emails, all right? And the other is the electronic certificate that's attached to the back of filings that is an automated certificate of e-service generated by the e-filing system that had Ms. O'Loughlin's name on it. And interestingly enough, the reply brief filed in this case in this court has Jackie Marlowe's name on it, all right? So apparently Hicks-Thomas has not implemented a screening procedure with Jackie Marlowe. Even after the conflict was raised, she continues to work on this case. So they say the lawyer should read these e-filing certificates and then communicate the contents of the e-filing certificates to, and this isn't about the body of the pleading. We wholly accept the idea that lawyers are responsible for reading pleadings that are filed. The lawyer should be reading these e-filing certificates. And then they should take those e-filing certificates and communicate them to their client and ask their client, hey, make sure you look here and see if anyone's listed here that might have ever represented you before in a case. So that standard is to set up what is essentially a reverse conflicts check database, right? We'd have to set up a database in our firm of everyone who'd ever represented a party, and then check every electronic communication, an email where she was copied on it, an e-filing certificate. And so they want to impute that knowledge both ways. They want to impute the knowledge from the e-filing certificate to me or my firm. And then they want to impute the knowledge that Felicia O'Loughlin previously worked on this matter from the client to me. So I'm supposed to know the contents of the e-filing. I'm supposed to communicate that to my client, make sure my client understands the implications of it. This might have someone on it who's previously worked on your matter, and then the client is supposed to get that information back to me. That's not in fact what happened. What happened was in January, while we were getting ready for trial, doing some other work, documents were forwarded to the client, and the first time they noticed and alerted that to me. I have those communications. They are privileged communications. I don't wish to reveal those written electronic communications, but I have them. And that's part of the problem here. The court accepted my declaration as to when I discovered this conflict and the client's declaration as to when they discovered the conflict as truthful. And even if the court were to say, we're going to disturb that factual finding, even if this court were to say, we're going to disturb that factual finding on waiver, we'd still have to go to the next question, which is, did that waiver cause prejudice to the other side? And they raise only one point of prejudice. They say, our client is destitute and can't afford to hire a lawyer. But our delay did not cause them to be destitute. They've been claiming to be destitute since 2011. They claim.
I thought under Marin Brothers, the question was whether your client was prejudiced, not whether their client was prejudiced.
Well, the question under Marin, and this is mixing two areas of disqualification law. Marin would ask the question of whether my client was prejudiced for the purposes of disqualification under a scenario that does not involve side-switching lawyers and paralegals. And so I'll get to that in just 1 second to clarify Marin and Metters, if I can. I wanted to finish what I think is an important thought on the prejudice, and then I'll loop back to that, so I'm going to make myself a note to do so. On the prejudice point, Adil Zaidi would have to show, which the only evidence in the record is a statement from Mr. Harrison, that he believes that his client doesn't have assets, and that he believes that his client would have a hard time hiring a new lawyer. But there's no declaration from Mr. Zaidi. And why is there no declaration from Mr. Zaidi? Because the trial court previously sanctioned Mr. Zaidi for failing to comply with discovery obligations and told him that he cannot put on evidence of his assets and net worth in this case because he refused to comply with discovery. So the trial court, sitting on this information, is making judgments about the credibility of the parties and about the prejudice that this court shouldn't disrupt. But even if we accepted it all as true, Mr. Zaidi's claimed that he didn't have money since 2011. Certainly after I got a $50 million judgment against him in the first trial of this matter in 2014, he claimed that he didn't have any money afterwards. Nothing about and it's not an 11-month delay. First of all, nothing about the delay period, which I think was about 7 months before we found the issue from the first time Felicia O'Loughlin made an electronic filing, all right, at which time I wasn't aware of the conflict. But when the issue was raised, we did some research to figure out what the parameters of this were. I haven't had this issue come up before. We then raised the issue in writing with Mr. Harrison, asked him to answer questions. He did not answer those questions for us, and so we moved to disqualify. It wasn't a matter of, he wants to measure it off to the day of how far back it was from a trial setting. He doesn't include the time period when we were communicating with him in that. The court found there was no prejudice, the court found there was no waiver, and the court found that Hicks Thomas reasonably should have known of the conflict had it taken appropriate steps to determine that. And back to Mirren and Metters and why they're different. All right, Mirren and Metters require a showing of prejudice to my client. Phoenix Founders and his progeny do not require that showing of prejudice. And the reason that it doesn't, Phoenix Founders...
Why shouldn't they?
Well, great, wonderful question, Justice Busby. I appreciate that. It's like a pitch right down the middle for me. So, and that's the reason for that is that Metters dealt with a situation where there was an inadvertent disclosure of a confidential piece of information. So my firm, hypothetically, gets a document, and it's a privileged document. All right? We didn't do anything wrong. We have this document. The question is, should we be disqualified because we've seen it? Now we have the document. We can weigh that evidence. We can weigh what that disclosure was and what prejudice might be suffered. When we have a side-switching lawyer or a side-switching paralegal, we can't measure the prejudice because of the very point, Justice, that you brought up, which is you believe that Ms. O'Loughlin didn't disclose confidential information, but you don't know that she didn't disclose confidential information. And the only way to know whether she just...
the representations of a member of the bar of the court that no such confidential information was received?
So the representation, if it were to be accepted, goes as far as it goes. What Mr. Harrison actually represented is Felicia O'Loughlin didn't disclose any information to me. Doesn't say she didn't disclose it to anybody else in the firm. Doesn't say she didn't disclose it to the client. And how would he know, right? Didn't get her declaration saying that she didn't. But I would say this about lawyers. I trust lawyers too. I think they are as honest as the average person. I think no more so. And what we would be doing if we set up a test that says, with a side-switching lawyer, a side-switching paralegal, we're just going to ask them. Let's just ask them if they shared any confidential information. I think I can tell you what problems might occur when I think people are even less than average honest when they're incentivized not to tell the truth. And I think what we would be creating in the bar, right now the bar polices itself, and that's the job of the lawyer, right, with the paralegal. The lawyer is bound by 1.09. So the lawyer has to make sure their whole staff adheres to 1.09. And when a lawyer says, we're going to make sure that our staff adheres to 1.09 by not including them in conflicts checks, by not admonishing them not to work on cases or against clients they previously represented. When we bring on new lawyers, we're not going to do anything to admonish them. And then what we're going to do, hypothetically, is create a test that says, well, if something comes up, we'll just ask them if there was a disclosure. There's no way for me to test that. First of all, to test that, and this is exactly what, I'll think of it in a second, exactly what I think it was the Turner case, or American Home Products, Grant case. Grant says exactly this. We're not going to make you disclose your own confidential information to see if the other side has it. So first of all, Justice, I'd have to say, here's what I told Felicia O'Loughlin. Here's all the confidential information she had access to. Then I'd have to ask the other side, did you get any of that confidential information? And the other side would, most often, truthfully answer the question, but sometimes not. And there'd be no way for me to verify that. Am I going to get electronic discovery of Hicks Thomas's files, and all the communications between Felicia O'Loughlin and her client, or the other lawyers in the firm?
Well, let's just assume.
Sure.
These are very strong points. I don't mean to say that they're not, but let's just assume that we can get past it, and we're persuaded. Trial court is persuaded that there were just a small handful of instances. It was typing up something. The paralegal credibly says, all I did was, take the stuff and file it or type up the things. I never really talked about it with anybody. It's whatever, and we're persuaded. That doesn't necessarily mean that you're off the hook. And so the question I also have is, what sort of sanction short of the ultimate sanction of disqualification might be possible in that situation or in this one or something else? Does it have to be binary up, down, and we either completely disqualify the entire firm, or is there something in between that our legal system might have that would create the disincentive that I think you're quite rightly invoking, the temptations and all the rest of it that all human beings would face. Well, in this instance, it's come to light, here's what's going to happen to you, but it might not be disqualification. What might that be?
Yeah, so the first part to answer the question you didn't ask is that would overrule Columbia Valley. But to answer your question, here's why I don't think anything other than disqualification would work, right? And that is that then you'd be relying on, let's say we said, well, we'll just firewall off Robin Harrison inside Hicks Thomas, and we'll firewall off Felicia O'Loughlin. So now we're making sure that we're relying on the conflicted lawyers to tell us everyone, and to remember accurately, everyone who might have received the fruit of the poison tree, so to speak, right? And so the consequence of trying to firewall it off is we'd never know if we got it right, because we don't know what they knew and we don't know what they disclosed to whom and when. And we'd be relying on the firm that didn't bother to run a conflicts check on its paralegal, and relying on the firm that didn't admonish its paralegal not to work on the case to be the safeguard of that information and to be accurate, even if they're acting in the best intentions. The consequence, like I said, you don't look both ways when you cross the street. The consequence is you might get hit by a car. Just look both ways.
But if you do, you might not necessarily die.
Well, you might not die, and they're not dead either.
Don't we trust firms all the time in discovery? Don't destroy this document. Our whole system is built on a measure of trust. So if there is something, and my premise was, if we conclude this was just negligence and serious negligence, I don't think anybody, I doubt that the same policies are running rampant at that firm or any firm that's heard about this case since. But if that's the conclusion, that just seems different than it now puts us in a situation like a firm that has been somewhat sloppy with discovery, and and that happens, right? But we don't disqualify the firm altogether. There's some sanction for it.
Great question, and can I continue to answer that? Thank you, Chief Justice. I love that question because that's what the Metters line of cases is all about, right? The Metters line of cases says, in some circumstances, we're going to look at what happened and go into the detail of it, partly because it's knowable, right? Like I said, if a document's inadvertently sent that's a privileged document, we know and we can weigh it, and we could even potentially see who had access to it. There's another line of cases where we say, hey, safeguarders of 1.09, lawyers, you've got to make sure that this is adhered to. And so what we've set up is a series of bright line rules. One, you've got to have a system to where you are trying to figure out whether there's conflicts. You've got to detect every conflict you could reasonably know. Conflicts checkers are how we do it. Hicks Thomas chose not to include their paralegals in the conflicts checks. But then we have other safeguards. Even if you don't pass that hurdle, okay, then what we're going to go to is, if you pass that hurdle, then we're going to make sure that you're cautioning the people who are not themselves bound by those rules. The paralegals are not 1.09 professionals. They're not lawyers, right? Some legal secretaries, some of them might not even have college educations that are working. Some of them might have master's degrees. It's a variety of different types of people. So we've got to make sure that we're telling those people, here's the rules. Don't work on cases that you previously worked on, and don't tell anybody any of that information. And then we've got to set up separate safeguards. But if you don't do that, what we're going to do is we're going to, and there's this series of drop downs, irrebuttable presumption that you learned information, irrebuttable presumption that you disclosed the information, and then, yes, disqualification is automatic. It is a harsh remedy that's easy to avoid. I couldn't find a single case in Texas where the Supreme Court has disqualified a firm that met the Phoenix Founders standards. Even when a conflict arose, disqualification didn't happen. And that's the answer.
Thank you, Mr. Mead. Your time has expired.
Okay. Thank you.
Any further questions? All right, thank you, Mr. Mead. And Mr. Harrison, you have 5 minutes.
Thank you. To touch on a few things that counsel spoke to, the trial court didn't make findings in this case. The order is part of the appendix to the brief. It simply says that our firm is disqualified. It certainly didn't make any inquiry or finding about the firm's conflicts measures, because that's not a question that is considered outside of those that are addressed in the Phoenix Founders case. It didn't get into what did the lawyer know or what did the lawyer not know. As an aside, my affidavit states that we were not provided any confidential information in connection with the prior involvement of Ms. O'Loughlin at the prior firm. There are two issues, really, three that we've addressed, but two important issues to be addressed here. Was the risk of disclosure of confidential information under these facts and circumstances that the court has to consider acceptably low? And I think under these facts and circumstances, the record shows that that was in fact the case. Now, the court does have to address whether or not the Turner rule bars that consideration in this case. I think under the facts of this case, the Turner rule doesn't apply to strictly prohibit the court from considering those factors.
What sanction do you think would be adequate? None?
Your Honor, I think that if the court were to go back, if there were to be a finding or a consideration by the court that there's been some disclosure of confidential information, then the court could order in limine that that information could not be used at trial. Remember, this case was tried once. There are no secrets here. This case has been appealed once. It's been around now for 16 years. So I don't know that there could be a sanction that would be necessary, but if in the analysis, if in an in-camera submission, the plaintiff here was to say, this is confidential information that we think would be harmful to us if it were used in the case, the court could order in limine that that information could not be used. Issues of strategy, witnesses, witness examination, and so on are not secret here. And in the Murin case, the court noted that probably there was no confidential information that would be harmful in a prejudice analysis. Then the question is there prejudice here? Well, there is massive prejudice to the defendants, Mr. Zaidi, Mr. Shah, and Prestige Consulting in this case. No question about it. Counsel said that the only issue here was whether or not they could afford other counsel. That's not the point. It's a point. They will be, as we've presented in the record, they will not be represented if this case is tried again. That's a huge strategic disadvantage, but it's also an extremely complex case. The trial court docket sheet is 51 pages long. There are 16 separate causes of action reported in the trial court's first judgment. $40 million in damages were awarded between actual damages and punitive damages. I know this case. No other counsel could properly represent these people if they could be hired as long as this case has lasted. The prejudice here is severe, and in light of the facts and circumstances, the low likelihood of any disclosure, of any confidence, we believe that the trial court abused its discretion, and mandamus should issue to correct that. If there are no questions, that's all I have. Thank you.
Mr. Harrison, thank you to all counsel. The case is submitted, and that concludes the arguments for today. The marshal will adjourn the court.
Rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.